So why do you think that this case needs to be reviewed?
Well, I'm sitting here this morning with Jaideep from Orissa, and he's come with a draft of the review petition. And I must say, I was so pleasantly surprised to see what comprehensive work all of you have put in, and the kind of draft that you've prepared is top class. I have no doubt in my mind that the review petition needs to be done. I also have no doubt that the Supreme Court made a huge mistake in reverting back to the 3-year rule after 22 years. And more than anything else, I am rather surprised that it was done in the manner in which it was done. There was little consultation with law professors who would have their own idea. There was no consultation with students who were terribly affected by this judgment. And the review petition prepared by Jaideep, and I've helped him a little bit working on that draft, I am confident that it is a very good presentation of the grievances of the aspirants. Now, a review petition generally has not much chance, generally, but a petition as well prepared as this is. And I suspect once our review petition goes to court, many other aspirants from different parts of the country will also file review petitions in the Supreme Court. Yours is a model because it is very exhaustive, very comprehensive, and very learned draft of the review petition. And I think we have today a decent chance of succeeding. We must succeed. We must, because the injustice done is too severe and it will have widespread ramifications right throughout India, all across the world. You don't have law practice generally for inductment in the judiciary at the lowest level. At higher levels, yes, but not at the lowest levels. I hope we change things.
So are there strong grounds that we have raised? And what do you feel is the aftermath after 22 years of change that has been brought about? And so this review petition is unique because the judgment was delivered by a sitting Chief Justice. And what are the possible challenges and possible outcomes for the reliefs that we are seeking?
Well, I feel the main problem was that the inputs that the Supreme Court needed in terms of academic research and comparison in the world situation, and considering the point of students, etc., considering backward class students, SC, ST, OBC students, considering PWD students, considering women and other disadvantaged sections. I think hardly any input went into the Supreme Court judgment. And I feel sad that an issue of such importance is being treated like this. And we must win. We must change. One important point that Jaideep has brought to my notice is that when the discussion first started on the necessity for the 3-year rule, at that stage, training in India, pre-selection judicial training, was not the norm. There were hardly any institutions that were doing that. And so somehow in the past, it may have been necessary then, because training was absent, to think of some rule. Even then, Supreme Court judgments, Law Commission reports all pointed out that we must go by training and not by the 3-year rule. Even then, today we have a huge expansion of training in the country. You have many models for good training for judicial officers. Why should India today, when training is so entrenched and judicial training is more than a substitute for the 3-year rule, much more than the 3-year rule, why should we revert back to an ancient system? When when we all know so few law graduates actually go for law practice? And we know what happens with law practice in this country. Sometimes it's merely getting your name on a vakalatnama with a senior person. And you go to backward class candidates who have passed the exam and want to become a judge. You know that their seniors often from the dominant community will put your name on the vakalatnama, but they will hardly be given a chance to draft and never given a chance to argue in courts. So the 3-year rule is obsolete and defunct. And I'm proud that all of you took the step to challenge this order. I only wish it was done earlier, but you had no chance because notices were not issued to law professors. Notices were not issued to students. And it's a mistake, I think, on the court's part. And the mistake, of course, on the part of the civil society is that we didn't prepare a proper brief to argue at the level of the Supreme Court. But I would say the mistake on the part of the court in not giving notice to professors and students and, academics who would have contributed enormously to this discussion. That mistake is a fatal mistake. I hope the Supreme Court I'm confident that the Supreme Court may actually, realize the enormity of the mistake and reopen the case.
So we have hope then we can fight against this justice if we all join hands and make it as a movement of all sorts.
I want to say as a last submission really, or as a last suggestion to you, students who are affected by this judgment, and there will be lakhs of students in this, should get together, apply their minds, sit with their law professors, and file review petitions rapidly and quickly. It's very important to do it quickly. And if I can give you a deadline, it should be before the Supreme Court opens in the middle of July.
Yes.
You must make comprehensive, professional, academically sound review petitions and file them quickly from all across the country. And get your professors to be petitioners, not just students. Get your professors, get academics to join this struggle for the correction of this judgment.
Sure.
Good luck, everybody.
Thank you.